everyone present here. On behalf of Department of Law, Sister Nivedita University, I, Pragya Lama, Research and Drafting Head of the Moot Society, extend a warm welcome to this gathering present here today for the inaugural ceremony of late Honorable Justice M. Fatima Bibi Memorial Moot Competition 2026. Today marks the commencement of an intellectual journey for our students, the aspiring advocates of the future, as we step into the simulated courtroom arena to sharpen their advocacy skills and legal acumen. Today, we are deeply honored to have amongst us our respected chief guest, Sri Subroto Talukdar, former judge of Honorable High Court at Calcutta and the chairman of One Man Chit Fund Committee, West Bengal. Our guest of honor, Professor Dr. Nirmal Kanti Chakraborty, Chief Advisor of Swami Vivekananda University and the former Vice Chancellor of West Bengal National University of Judicial Sciences. Honorable Chancellor, Shri Satyam Roy Chaudhary, Sir. Honorable Pro-Chancellor, Professor Dr. Dhrubajyoti Chattopadhyay, Sir. Honorable Vice Chancellor, Professor Dr. Anupam Basu. Honorable Pro-Vice Chancellor, Academics, Professor Dr. Madhumita Guha Majumdar. Honorable Pro-Chancellor, Pro-Vice Chancellor, Administration, Mr. Supratim Sen. Honorable OSD to Chancellor, Mr. Pradyut Kumar Biswas. Honorable Registrar, Mr. Sumanto Basu. Honorable Chief Financial Officer, Mr. Subir Rakshit. Honorable Dean, School of Law, Professor Dr. Debashri Mukherjee. Professor Dr. Manik Chakraborty, Professor Emeritus of Department of Law, and distinguished faculty members, esteemed judges for the competition, our dear participants and students.
I, Debashri Biswas, Vice President of Moot Court Society, extend a warm welcome to each one of you here. Your presence today signifies encouragement, support for our students as they embark on their journey into the world of courtroom advocacy. May I now request our esteemed dignitaries, our chief guest, Sri Subroto Talukdar Sir, former Judge, Calcutta High Court, Professor Dr. Nirmal Kanti Chakraborty Sir, Chief Advisor of Swami Vivekananda University, our Honorable Chancellor Sir, Sri Shottam Rai Chaudhary, Honorable Pro-Chancellor Sir, Sri Dhrubajyoti Chattopadhyay Sir, our Vice Chancellor Sri Anupam Basu Sir, and our Dean Ma'am, Professor Dr. Debashri Mukherjee, to kindly come on the dais for the watering of the plant that symbolizes growth and new beginnings, accompanied by the singing of Saraswati Bandana by our student Swarariti Das from BA LLB Semester 3.
या कुन्देन्दु तुषारहार धवला या कुन्देन्दु तुषारहार धवला या शुभ्रवस्त्रावृता या वीणा वरदण्डमण्डितकरा या श्वेतपद्मासना या ब्रह्माच्युतशङ्करा प्रभृतिभिः देवैः सदा पूजिता सा मां पातु सरस्वती भगवती निशेष्य जाड्यापहा सरस्वती नमो नमः.
May I now request the dignitaries to kindly take their seats? inaugurate this event, I now invite our Honorable Chancellor, Mr. Satyam Roy Chaudhary, sir, to formally deliver the welcome address.
Very good morning, everybody present here. Our respected chief guest, Sri Subrata Talukdar, former judge of Honorable High Court at Calcutta, and the chairman of One-Man Cheat Fund Committee, West Bengal. Our guest of honor, Professor Dr. Nirmal Kanti Chakraborty, Chief Advisor, Swami Vivekananda University, and the former Vice Chancellor of West Bengal National University of Judicial Science. Honorable Pro-Chancellor, Professor Dhruvajyoti Chattopadhyay, our Honorable Vice Chancellor, Professor Anupam Basu, eminent dignitaries from bar and bench, academics and law firms, all participating teams, my colleagues from Sister Nivedita University, and dear students. Good morning, everyone. It is my great pleasure to welcome you all to the late Honorable Justice M. Fatima Bibi Memorial Moot Court Competition 2026, organized by the Moot Court Society of the Department of Law, Sister Nivedita University. I extend my warm welcome to the distinguished members of the bar and bench, eminent academicians, legal professionals, faculty members, and 30 participating teams from reputed law institutions across the country. This competition is much more than a contest of arguments. It is an opportunity to sharpen the skill that define a good lawyer: research, reasoning, articulation, conviction, and above all, integrity. It is deeply meaningful that we honor the memory of Justice M. Fatima Bibi, a trailblazer who became the first woman judge of the Supreme Court of India. Her journey broke barriers and demonstrated that excellence, courage, and integrity know no gender or boundary. Her legacy continues to inspire generation of young lawyers and students. To all the participating students, I urge you to compete with confidence, but also with humility. Remember that true purpose of law is not merely to win an argument, but to uphold justice, fairness, and the truth. At Sister Nivedita University, we believe education must create professionals who combine knowledge with character. Our Department of Law is committed to creating young professionals who are not only competent in their chosen field, but also conscious of their legal responsibility that comes with the legal profession. I congratulate the Department of Law and the Moot Court Society for this initiative and wish every participant the very best. May this competition inspire young minds to become not just accomplished lawyers, but worthy custodians of justice. Thank you, and once again, I welcome you all to Sister Nivedita University. Jai Hind.
Thank you so much, sir, for your words of encouragement. Your words have truly enlightened the atmosphere for today's event. It is now my very privilege to invite our Honorable Pro-Chancellor, Professor Dr. Dhruvajyoti Chattopadhyay, sir, to grace this occasion with his presence and motivate all our participants and students for this competition ahead. Please, sir.
Very good morning to everybody. Respected Chancellor, sir, the respected chief guest of this program, and also we have our guest of honor on the dais. We have our Dean of School of Law, as well as number of dignitaries in this hall, along with the participants from different universities and law schools. Dear students of our law department, and definitely the faculty members who are present over here. The Department of Law actually organized this National Moot Court competition under this Association of Indian Universities. And that's the first effort taken by them to have the national level moot court competition. And it was a grand success. And AIU specifically mentioned number of times this particular program which has been organized. And that time, it was only, I think, 3 years of the law school. And at that time, it has been done. But after that, it is only because of the encouragement of the faculty members, now we have our students who form this Moot Court Society. And now the Moot Court Society itself organizing this program. Let's give a big hand to this Moot Court Society members and all our law students who are behind this whole program. Now, I'm sure the participants who are present over here, all of you understand this Moot Court competition is far more than an academic exercise, where the students argue a hypothetical case before a simulated bench. But it is one of the intellectually demanding and professionally relevant forms of experiential learning. And experiential learning is one of the major things of NEP 2020. And in that respect, this program is really an outcome of this successful implementation of NEP 2020 in our university. Now, I'm sure that all of you know that this word moot has its origin in the Old English tradition of debate and deliberation. Historically, a moot referred to a gathering in which questions were discussed and arguments advanced. But at the heart of every successful moot court competition, it lies a legal research. And the preparation of a memorial or written submission is consequently an exercise in precision. And the different rounds, what has been planned, you have seen that on this for the next 3 days is definitely going to have where all the different aspects of this moot court competition is going to be there. But the educational value of mooting extends beyond law itself. It develops the research skills, which is very important for the law students, and also the analytical thinking, writing ability, the public speaking, and the teamwork and time management. Time management is very important. You know that this is one of the very important things which has been considered in this competition. And what I just wanted to mention that for the universities, hosting this moot court competition is consequently an opportunity to strengthen the culture of experiential learning, bringing the members of the judiciary, the senior advocates, the academics, the legal practitioners, and students into meaningful interaction. And coming to the end of my lecture, I just wanted to say that the modern moot court must also respond to the changing character of the legal practice, the artificial intelligence, the cyber crime, the digital commerce, the data protection, and biotechnology, climate litigation, international investment, all are generating legal questions that would have appeared unfamiliar to earlier generations. And that's why it also reminds the future lawyers that the law must continually respond to the technological and social transformation without abandoning its fundamental commitment to justice. And to end, I must give my pranam to the name, the Honorable Justice M. Fatima Bibi Memorial Moot Court Competition. This this Fatima Bibi, as mentioned by our Chancellor, the first female judge in the Supreme Court. But it is also important that she was also the governor of Tamil Nadu and received the highest order, Padma Bhushan. But after it posthumously, she received this award, Padma Bhushan. So it's very, very important that we are organizing this moot competition in her memory. Thank you. Namaskar to everybody.
Thank you so much, sir, for your kind words of inspiration. You have focused on the history of mooting as well as experiential learning, as well as incorporating technology, law, and the future of justice. Thank you so much, sir. We will now request our Honorable Chancellor, sir, Mr. Satyam Rai Chaudhuri, to kindly felicitate our distinguished chief guest, retired Justice Sri Shubroto Talukdar, former judge of High Court at Calcutta and chairman of One Man Cheat Fund Committee, West Bengal, and our guest of honor, Professor Dr. Nimal Kanti Chakraborty, sir, the chief advisor of Swami Vivekananda University and former vice chancellor of WBNUJS, with Utturyo and a small token of appreciation.
Now I would request our Honorable Vice Chancellor, Professor Dr. Anupam Basu, sir, to kindly address the gathering and inspire our participant with his invaluable words. It is already.
A very good morning to all of you. I'm sorry I reached a little late. It's indeed a pleasure that today we are hosting a memorial moot court competition in the honor of Honorable Justice M. Fatima Bibi. She was, as far as I could gather, she was the first justice, woman justice in India. And also, I think she later on took up the position of governor of Tamil Nadu. Now, such a luminary person is being honored by today's moot court competition, which will be which will host a number of young, budding lawyers, advocates, and future judges. Sister Nivedita University is also proud of its Department of Law, which regularly organizes such events and is one of the, what should I say, one of the flag bearers of the university. And it is only in the fitting of the things that they are hosting such a prestigious event today. We have got honorable judges on the dais. We have got honorable judges also. They will be there as judges for this moot court competition. But only one thing I'd like to mention to the participants, that I can see the glitter of the awards that are there, but those awards will be won by some, but not all. But that is not the most important question. The most important question is that in this process, all of you will learn to make your case, learn to fight for justice, how to present your case for justice, and that is most important. Awards come in the way, and of course, whoever gets it is an additional encouragement, but that is not the end of the road. So I am sure that you will keep that spirit in mind when you take part in this moot court competition, and I'm sure that this program will augur very well, and keeping in view of the tradition and keeping in mind the honor of the lady whom we are commemorating today, this will be a grand success. Thank you very much.
Thank you so much, sir, for your inspiring address. Now, I humbly invite our esteemed chief guest, Shri Subrata Talukdar, sir, who's the former judge of High Court al Calcutta and the chairman of One Man Chit Fund Committee, West Bengal, to grace the occasion with a special address. And we would be truly honored to have your invaluable insights to inspire and guide our participants as we begin today's event.
Good morning, everybody. My special wishes to the members, distinguished members on the dais, the faculty of the dais, the students, and everybody who is here. And on this important occasion where students are to be trained in moot court, in conducting and participating in moot courts. You would excuse me, but I have my thoughts written down on a piece of paper. I shall be tolerably brief. And the focus, as far as the moot court competition today is concerned, is on artificial intelligence. The problem is there. So I decided to concentrate my address on the aspect of artificial intelligence and the law. Now, I begin by showing today's Times of India, which is in the very first page, is something which has been relevant to us in our artificial intelligence debate. It is about the NET row, the National Examination row. And the headline is, Artificial Intelligence, AI, used recklessly to draft questions, say experts. So it is very coincidental that today's headlines can coincide with whatever is the issue regarding artificial intelligence to be discussed in the moot court, the problem given to us. And my thesis would be that artificial intelligence cannot be at the expense of a human component. The basic premise, and I shall just cut short the long part of my written speech to give you an insight about what are my thoughts on artificial intelligence. So let us begin by asking the appropriate question. And now may I just present that. The appropriate question is not simply what is the law relating to artificial intelligence. The more meaningful questions are how are our existing legal principles responding to AI? What are those principles adequate? Where do they require development? And in what direction should the law evolve? The first point is from technology as a tool to technology as a participant. The legal profession has never been unfamiliar with technology. The printing press transformed legal publishing. The typewriter changed legal practice. Computers transformed research, and electronic databases changed the manner in which authorities are found. E-filing and video conferencing have altered the administration of justice. But artificial intelligence presents a somewhat different challenge. It does not merely store or transmit information. It can analyze, classify, predict, translate, summarize, and generate. It can produce text, images, audio, and video. It can assist in analyzing enormous bodies of material. It can even produce what appears to be legal reasoning. Mark the language, what appears to be legal reasoning. And therefore, technology is no longer merely a tool which executes instructions. Increasingly, it participates in the production of material upon which human beings make decisions. Again, I repeat, it produces materials on which we base our reasoning. That brings us to the first principle which should guide the evolving law of artificial intelligence. That is, and this is I emphasize, the more consequential the decision, the more important human responsibility becomes. First, a machine may tell us what is probable. The law may require us to decide what is fair. Second, a machine may identify a pattern. The court must determine whether that pattern has legal significance. Third, a machine may predict, a judge may decide. Now I take you to the constitutional state. I'm just giving the examples. For example, take Article 14, equality before the law and equal protection of the law, a fundamental right in the Constitution. They do not cease to apply because a decision is made through an algorithm. An algorithm may appear to be neutral, but if it is trained on historical data containing social or institutional biases, it may reproduce these biases on a much larger scale. The constitutional question, therefore, cannot be answered merely by saying the same algorithm was applied to everyone. The deeper question is the classification reasonable or consequence constitutionally permissible? The jurisdiction beginning with E.P. Royappa versus State of Tamil Nadu and developed through Maneka Gandhi versus Union of India has taught us that constitutional equality is not satisfied by mere formalism, where the substance of state action is arbitrary. The fact that discrimination is expressed in codes rather than in words cannot make it constitutionally acceptable. Similarly would be right to privacy. Article 21, we are all familiar with the judgment of K.S. Puttaswamy versus Union of India. Now, as far as privacy is concerned, and this is a comparison which I'm trying to present, I'm trying to make out a case before our moot court panelists, a comparison between algorithm-based codes which supply material for decision-making and the aspect of human decision-making itself. Now, as far as privacy is concerned, the point is, the jurisprudence assumes importance in the age of AI because AI depends heavily on data. Our photographs, our voices, our movements, our preferences, our transactions, our communication, our digital behavior. AI raises a question beyond the collection of personal information. It may permit conclusions or inferences drawn from the information. that the question may no longer be merely what data has been collected about me. It is not merely collecting data. AI is processing that data and throwing up its own conclusions. It is how, as you lawyers and would-be jurists, handle that data to fit into the legal paradigm. Now let us see, it may become, what has a machine inferred about me? What consequence follows from that inference? That is an important emerging constitutional question. As we all know, the Digital Personal Data Protection Act 2023, together with the Digital Personal Data Protection Rules 2025, is an important part of India's legislation. But AI demonstrates that privacy law by itself cannot answer every question. The constitutional values of dignity, autonomy, equality, and liberty must continue to guide the interpretation and development of the law. The simple proposition is, friends who are sitting here would be going into the moot court with their arguments, you merely cannot depend on the data alone, and you cannot depend on the analysis thrown up by the data. I may be sounding overtly pessimistic about AI, but I dare say that the human component which is in your brains, your sense of analysis, must be allowed to override every AI thrown data thrown at you. Now, same will go with freedom of speech and synthetic reality. It is interesting, the law must protect freedom of expression, which also addresses legitimate concerns relating to privacy, reputation, fraud, and manipulation. The question is, how do we combat harmful synthetic content without creating a legal machinery which gives the state excessive powers to determine what is true? Then I'll go to the question of natural justice. Natural justice is also an aspect where an algorithm categorizes a person as high risk. Suppose AI says somebody, a data thrown up on an Interpol website, thrown up in a lookout circular, says that a person is at high risk. Now let us see how the natural justice formula will fit into it. The affected person asked, why? And the answer would be, the algorithm has decided so. The answer may not satisfy the requirements of natural justice. The principles of fairness and reasoned decision-making cannot simply disappear because the decision-making mechanism has become technologically sophisticated. This gives rise to an emerging concept of algorithmic explainability. The more serious the consequence, and please mark these words, the more serious the consequence for an individual, the greater the need for meaningful explanation, human review, and an effective opportunity to challenge the decision. I'm sure this is also a lesson for us who are in courts and those who are in courts about to pass judgments on issues such as this. The more consequential the decision-making, affecting a person, as we go back to Articles 14, 21, even right to freedom of speech and expression, the more consequential the decision-making, the more the requirement for a human review. Now we come to AI and the judicial process. I'm actually trying to make it brief as much as possible for the audience so that I do not interlude much between you and your moot court. AI-generated legal material must be verified before it is relied upon. A lawyer cannot cite a case merely because an AI system has supplied the citation. You'd recall there was a faux pas in the Supreme Court recently where there was some pleading where generative AI was used. And that generative AI yielded material which was not apropos the submissions to be made before the court. So the human review factor is very important, and that is my thesis for the day. A lawyer cannot cite a case merely because an AI system has supplied the citation. The judgment must be located. Sir Raj Bihari Ghosh, famous lawyer, who had so many books in his chamber, and there were no tablets, iPad in those days, was asked by a client, have you read all the law? It seems, he says, no. I have not read all the law, but I know where to locate the law. So that is what law, after all, is an applied science. It is an applied form of art also. So the question is, you have to know what to locate. And even in AI, your job is to locate whether the material is verifiable, material is apropos the case you're making out. The judgment must be located, the proposition must be checked, the paragraph must be read, the authority must be current. In legal practice, fluency is not authority and confidence is not correctness. The machine may assist the lawyer in finding the law. It cannot relieve the lawyer of the responsibility to know the law. We are trained because there is a frequently asked issue which juniors will face. What is the ratio of this judgment? I remember when I left for an outstation case during my practice days, I left a case to a learned lady junior. And she was very new to the bar, so I told her, you consult so-and-so senior as far as this case is concerned in my absence. So the first question which the senior asked her, what do you think is the ratio of this judgment? And her reply was classic. She said 50-50. So the question is, after I came back, I could not face that senior for a long time because it was 50-50. So this ratio is dependent on a human understanding. My whole earnest plea to the young audience here is, don't surrender to AI. Keep your human faculties alive because you're training as lawyers to distinguish, to discern and find the ratio. Now let us see what a particular conversation with AI might go. The Bharatiya Shakya Adhiniyam 2023 contains provisions dealing specifically with electronic and digital records, including sections 61 and 63. Now, AI introduces a new evidentiary difficulty. Traditionally, the question was, is this document genuine? The digital age asks, is this electronic record authentic? The AI age may now require to ask, is this image, voice, or video synthetic? A recording may exist as a genuine digital file and yet not represent a genuine event. This is very interesting. The entire thing may sound genuine, and that is what we have all, the word which is currently doing the round, scams. The entire thing may sound genuine, but it is actually synthetic. It does not correspond to a genuine event, which is for the lawyer to decipher and the court to decide. The law will increasingly have to consider questions of provenance, authentication, integrity, metadata, and chain of custody. Yet, this principle remains familiar. The court must be able to assess the reliability of the evidence, but the methods of establishing reliability may have to evolve. However, a unique hash value is being now used as per the Shakya Adhiniyam in case of electronic records. Your job has now become manifold, multifold, and you have really now not only to do with physical records, but you can also have to now deal with the problems, the conundrums thrown up by AI. I now come to the concluding portion. What is the future lawyer supposed to do in this maze of probabilities? You are entering the legal profession at an extraordinary moment. This is my understanding. AI can search more rapidly than you can. It can process more material than any individual can read. It can produce a first draft in seconds. These are remarkable advantages. But there is also a danger. Do not outsource your thinking. Use AI, understand it, learn its capabilities, but also learn its limitations. If AI gives you an authority, verify it. If it summarizes the judgment, read the judgment. If it identifies a statutory provision, open the statute. And this is, I'll digress for a moment. Let me share it with my friends. As a lawyer and as a judge, nothing penetrates the skull more than the section itself. So the question is, I have seen eminent lawyer like the late Ram Jetmalani arguing in Calcutta High Court. I had time off. So I stood there in the courtroom, sat there, and I literally found that the eminent jurist was taking a class. It was as if you were in a classroom. His control over the sections, IPC, CRPC, Evidence Act, they had not been, was so natural that you could not beat it. And everybody had to be spellbound about it. In fact, there's a book by Frederick Forsyth, and the famous fiction writer. There are 4 categories of people: the good, the very good, the brilliant, and the last category, maybe Garfield Sobers, the batsman would have fitted into it. He is a natural. So the moment you become a natural, it is the hard work that makes you there. So I've seen that please do not ignore the basic sections. If it identifies the statutory provisions, open the statute. If it proposes an argument, test the argument yourself. The future lawyer will not merely be the person who can find information. The future lawyer will be the person who can distinguish. Finally, I have just these words of advice, if I may so. The technology will evolve. Issues will remain, but they have to correspond to technology. But as far as legal research is concerned, this moot court, which involves the question of generative AI, I was glancing through it. It will require expertise to handle, definitely. We are not being asked to predict the final form of AI law. We are being asked to think about the principles which should guide its development. The technology may be new, the questions may be unprecedented, but the constitutional method is similar. What is it? First, identify the power. Second, identify the right. Third, identify the consequence. Fourth, examine the justification. Fifth, apply the law. And last, and never lose sight of human being who stands behind the dispute. Because ultimately, the dispute is between 2 people in flesh and blood. It is not an AI-related dispute between 2 people. So how these people in flesh and blood would either benefit or lose from the outcome of the dispute, the lawyers must remember. You're not having an AI battle, a simulated battle on the screen. It's a real dispute. I conclude, I may leave you with one thought. It is this: the intelligence may be artificial, the technology may be evolving, the law may be adapting, but the responsibility must remain human. Thank you very much for the opportunity granted to me to share these thoughts, and I wish the participants in the moot court all the best. And as the learned Pro-Vice Chancellor pointed out, Vice Chancellor, the trophies are glittering. It almost tempts me to take one home. Thank you.
Thank you so much, sir, for your words of guidance. You talked about evolution of technology, the principles of natural justice, applied science and research, and lastly, you talked about responsibility for the humans. Thank you so much, sir. Now I request our guest of honor, Professor Dr. Nimakanti Chakraborty, sir, Chief Advisor, Swami Vivekananda University and former Vice Chancellor of West Bengal National University of Juridical Sciences, to share his valuable insights with us. Please come.
Very good morning to all of you. It is my pleasure to be here. What actually my feeling, because I was associated with Sister Nivedita University Law School in the first Association of Indian Universities, All India Moot Court from NUJS. I was also witnessed the first internal moot court competition among the students. I feel very much glad to see that the Moot Court Society, the team of Moot Court and the faculties, they have really developed their moot team, and that's why it is reflected today's gathering and everything I am feeling. I have already heard that the foundation of Moot Court already told to you. One thing I am very much glad also, so far my 4 decades of teaching in the law schools, this is the first time I have seen that any moot court competition being named in the honor of a lady, honor of a woman, and that is, I think, this credit to be given to the organizers also. And I am very much also feel happy that in the inaugural session itself, the challenges of participants today already highlighted by, started by Pro-Chancellor Professor Chattopadhyay, then our Chief Guest, Honorable Justice Talukdar also. But one thing I think what Vice Chancellor said, that this is a learning process. Moot court competition is a learning process. But what learning? If we take note of 2013 Singapore Declaration of International Association of Law School, that is, the 3 things are essential in the legal education: knowledge, skill, and values. So moot court is to impart skills, one of the part of skill development. And there, if we look into the transition of moot court competitions, that is also a transition from knowledge to skill also. But skill, that level has been changed. When I started my teaching career, that time also we have seen how students being prepared, how they perform. They are what also previous speakers highlighted, that individual skills, human intelligence to be given much important. But there was difficulties also we have to acknowledge, and how these difficulties being made easy by our present technology, particularly AI. I am referring you during COVID period, when AI also started, and also our international competition, moot court competitions organized in the online form also. There was one opinion poll online among the students and faculties throughout the globe about the whether we should allow AI in the competition or not. But the opinion reflected that is both the students and faculties are in favor of using AI, not prohibiting AI. Because in the JSOP, you have heard, those who are in the moot court competition, that the memorials, which is part of in your score, there are every chance of using AI and how to measure that. And it was also found that up to 95% AI was there, which are declared as one of the top memorials. In spite of that, the international academia in the legal field observed and still hold that use of AI should be encouraged. Question is not whether to use AI or not, whether to use technology, how to use it. To that extent, what is my suggestion to the participant is that there are memorials, or you can get the various conscious questions and answer from the AI on the facts, but synchronization of facts, abstraction of facts, not only from what Lord Denning learned us in the learning process of law, but also in the today's AI, you have to have developed your critical ability. It is not that AI will blunt your critical ability. Those who have that conscious questioning mind, they can use properly. And for that, how 2-3 things I will just suggest to participants and those who are also just our students, that you think how you can use your interpretation of statutes, general principles. Because if you look into interpretation of statutes, there are at least 14 general rules. If one of your participant applying harmonious construction, you can deny that by mischief rule or other rule. There are a lot of alternatives. It is not that there is only one answer. So how you can use your knowledge of interpretation, which particular interpretation would be counter to your opponent, and what would be more appropriate, you can link with the facts. And for that, I think your most appropriate attitude should be how you can link with present socioeconomic conditions and socioeconomic conditions or socioeconomic background of the particular facts in questions. So the question is not that there is limitation of algorithmic decision. Algorithmic decision making is not final, but algorithmic decision can help you to further questions. So what I can suggest that you use your AI in the form that your own and our traditional questioning, that is our culture, that is heritage. I will conclude by saying that our Indian tradition and Indian culture recognize the Kena Upanishad, that conscious questioning, that by conscious questioning you can get the truth. You can reach your ultimate decision making. So questioning yourself, particularly in moot competition, by questioning you can overcome the limitation of AI, you can overcome the challenges of today. Thank you and all the best. It is a learning experience. All of you will win. Those who will win the cup, they will definitely enjoy. But I think all of you will enjoy because it is a learning things. Thank you all.
Thank you so much, sir, for your wise words. You really focused on the 3 pillars of legal education, that is knowledge, skill, and values, as well as know how to use the AI and use your critical ability to interpret. Now I request and invite our faculty convener of the Moot Court Society, Sister Nivedita University, Professor Shomanjana Datta Chattakhani ma'am, to join us and brief about the participants about our competition.
Respected Chief Guest, Guest of Honor, and other distinguished guests, Honorable Chancellor Sir, Honorable Vice Chancellor Sir, Honorable Pro-Vice Chancellor Sir in Administration, Honorable OSD to Chancellor Sir, Honorable COO Sir, Honorable Register Sir, Honorable CFO Sir, Honorable Dean Madam, Department of Law, Honorable Professor Emeritus Sir, distinguished faculty members, esteemed judges for the competition, participants, and dear students. It is my privilege as a convener to welcome you all in the late Honorable Justice M. Fatma Bibi Memorial Moot Court Competition 2026, organized by the Moot Court Society, Department of Law, Sister Nivedita University. This second National Moot Court Competition is an endeavor to nurture the future members of legal profession by providing them with an opportunity to develop the legal reasoning, research skill, advocacy, and professional confidence. Mooting exercise is a unique position in the legal education. Through this competition, participants will have the opportunity to analyze the complex legal issues, conduct extensive research, prepare written submission, and also to present their arguments before the panel of esteemed judges. At this juncture, I would like to express my deepest gratitude to the honorable judges and the distinguished legal experts who have consented to be the part of this competition. I would like to extend my sincere appreciation to the authorities of the Sister Nivedita University for their support, to the faculty members, to the students, to the volunteers, and to all other members who have worked tirelessly to make this competition a success. Dear participants, you are aware of the rules which has been discussed by you on 17th August 2026. Now, regarding the competition, today in the day one, you will have the qualifier round in the first half and in the second half. In the day two, you will get the octa round as well as the quarterfinal round. And on the day three, you will get the semi-final and the final round. So prepare yourself, all the best, wish you success. Thank you.
Thank you, ma'am, for the detailed briefing and insight into the event. Before we come to the end of the ceremony, we would like to take a moment to express our heartfelt gratitude to the organizations that have made this competition possible. We extend our sincere thanks to our associate partners, Sinha and Company Advocates, Chaudhary Law Offices, and Judicium Associates for their continued support and belief in this initiative. Our special thanks goes out to Manu Patra, our knowledge partner, whose invaluable legal research resources continue to empower young minds like ours in the pursuit of justice. We are equally grateful to Law Bhumi, our media partner, for helping us amplify the voice of this competition and bring it to a wider audience. Our heartfelt gratitude goes out to Serena Publications, our literary partner, for their support in enriching the intellectual dimension of this competition. We would also like to acknowledge our accommodation partner, Comfort Stay PG, for ensuring that our outstation participants feel welcome and well taken care of throughout this event. Lastly, a heartfelt acknowledgement to Vocal Vakils and Dexon Global, our outreach partner, for helping us connect with the participants and spread the word far and wide. To each of our sponsors, partners, collaborators, thank you for standing with the Moot Court Society, Sister Nivedita University, in honoring the legacy of late Honorable Justice M. Fatima Bibi. Your support means more to us than words can express, and it is with great pride that we recognize you today.
May I now invite our Dean, School of Law, Professor Dr. Debashri Mukherjee, ma'am, to give the vote of thanks. Please, ma'am.
A very good morning to everyone present in this August gathering. It is said, lead with kindness, live with gratitude. As the Dean of the School of Law and the Patron-in-Chief of the Moot Court Society, it is my privilege to propose the vote of thanks as we come to the end of the inauguration ceremony of the late Honorable Justice M. Fatima Bibi Memorial Moot Court Competition 2006. On behalf of the University and the School of Law, I extend my sincere thanks to our respected chief guest, Sri Shubroto Talukdar, former judge of the Honorable High Court at Calcutta and the chairman of the One-Man Chit Fund Committee, West Bengal. We are deeply honored by your presence, and we thank you for sharing your valuable thoughts on AI and the role of the legal professionals in today's date. I also express my gratitude to Professor Dr. Nirmal Kanti Chakraborty, former Vice Chancellor, West Bengal National University of Juridical Sciences, and the Chief Advisor of Swami Vivekananda University, for gracing this ceremony. Your support and guidance mean a great deal to us, and your inspiring words to the budding advocates to keep them highlighted about knowledge, skills, and respect for the profession are important value-building lessons which I am hopeful that today's students will always remember. Endeavoring to host the National Moot Court competition and or taking any step forward in the best interest of the student has always been the endeavor of the School of Law, and we are truly blessed to have as our mentor the Chancellor of our university, Shri Shottam Roy Chaudhary Sir, for his constant motivation that he provides with us, with the trust and belief that he endows on us. On behalf of the School of Law, sir, I thank you for taking time out of your busy schedule and providing us with that spontaneous yes the moment we went up to you with our invitation. I also take this opportunity to thank one of the strongest supporters and guides of the School of Law, our Pro-Chancellor, Professor Dr. Dhrubajyoti Chattopadhyay. Your indomitable spirit, your perseverance for always making this department the best amongst all other departments of this university, and your positive approach has instilled the courage in the department and the school to bring out the best in us. I was listening to the speech delivered by our Vice Chancellor, Professor Dr. Anupam Basu. And from his speech, once again, we became very clear that he remains one of the strongest advocates of the School of Law. And under your able leadership and guidance, the School of Law has gathered the conviction to host this moot court competition. We thank you for your relentless support towards the school and for making this competition possible. Fairness in judgment lies at the core of every competition. I now take this opportunity to thank the legal experts, academicians, and advocates present here and who will be joining us in the next 2 days of the competition to evaluate the participating teams and bring out the best in them. Your experienced, your nuanced questions, and your eye to perfection will provide the participants with an important learning opportunity. A special word of thanks to all the participating teams from different parts of the country. On behalf of the Moot Court Society, we welcome you warmly to our university. Your participation has given this competition its true national character. I hope that the competition will help you improve your knowledge, develop your conviction and your confidence, improve your research skills, oratory prowess, and advocacy skills. And at the end of the third day, you all walk back home making new friends in the profession of choice. This competition would not have been possible without the unwavering support extended by other respected authorities of the university, namely the Pro-Vice Chancellor Academics, the Pro-Vice Chancellor Administration, the OSD to the Chancellor, the Chief Operating Officer, the Director, Academic Engagement, the Registrar, and the Chief Finance Officer of this university. The list perhaps is even longer, and on behalf of the School of Law, I take this platform to individually thank each one of you for your impeccable contribution in hosting this competition. I would also like to place on record our sincere appreciation for our partners and supporters who have contributed to the success of this initiative. We thank Sinha and Company Advocates, Chaudhary Law Office, and Judicam Associates for their support as associate partners, Manupatra for its support as knowledge partner, Law Bhumi as our media partner, Serena Publications as our literary partner, Comfort Stay as our accommodation partner, and Vocal Vakils and Dexnel Global as our outreach partners. To put this competition in place, the members of the Moot Court Society of the Department of Law have put in immense efforts. Every step has been taken to ensure that this competition begins and ends with the highest standards of professionalism. Their careful planning, dedication, and sincere efforts deserve appreciation. Every event organized by the School of Law has been strengthened with the support extended by the Departments of Mass Communication and IT. Assistance has also been extended by the administrative and support staff of the university. On behalf of the school and the Moot Court Society, I extend my gratitude to each one of you for your cooperation. Finally, I take this opportunity to thank the students for your presence at the inauguration ceremony and your overwhelming support in hosting this competition. This competition is not about arguing a moot proposition. It is about taking the initiative to develop all the attributes that are part and parcel of a good advocate, of an advocate who is not only knowledgeable, has the required research skills or the oratory prowess, but as our Chancellor Sir just now pointed out, that we have to be socially relevant legal professionals. As we honor the memory and legacy of late Honorable Justice M. Fatima Bibi, may this competition inspire our students to pursue the legal profession with integrity, discipline, and dedication. With these words, I once again thank all our dignitaries, faculty members, partners, participants, judges, student volunteers, and everyone present here for making this occasion meaningful. I wish all the participants the very best for the competition. Thank you and have a wonderful day ahead.
Thank you so much, ma'am, for your kind words of appreciation. Now I request all the dignitaries to please come to the stage for the photo session. Sir, please, photo session is there. Professor Shomanjana Datta Chattakhandi ma'am, Dr. Banita Bose, head of the Department of Law, and all faculty members, please come to the stage. Register, sir. Please.
To Dean Ma'am's office. Now I request all the judges coordinators to please escort our honorable judges to the boardroom.